Good morning, everyone. This is Sarah Willey here on a Monday morning, bright and early at 8 a.m. with my colleague Sandy Andre. You have found yourself at Miller Johnson's COVID webinar series. And today we're going to be talking about the 3 new laws that Governor Whitmer signed at the end of last week. And those laws relate to both business protection and also protection for the public and employees. The first to provide business protection in the form of liability immunity, conditioned on businesses doing certain things. And then the third law requires quarantine and isolation after a person has been exposed to COVID or has symptoms of COVID or has tested positive for COVID. And that third law has lots of implications for employers. So we're going to be covering those today, explaining what all of those say, and giving you all some recommendations as to what you need to be doing now with regard to those laws. Sandy is going to cover the first 2 of those laws, and then I am going to talk about the third one. So with that, Sandy, go ahead and take it away.
Hey, thanks, Sarah. Good morning, everybody. We will go ahead and start first by talking about Public Act 236. As Sarah mentioned, that is called the COVID-19 Response and Reopening Act. If you can go forward 1 slide, please. And generally, under this bill, businesses who act in compliance with federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19 are going to be immune from liability for a COVID-19 claim. In some ways, this is very straightforward, right? So all we have to do is be in compliance with all of those things. But for those of us who have been living and walking down this path for some time, we certainly know that the landscape has changed, and there's many, many places that we need to look related to COVID, federal, state, or local statutes, rules, regulations, executive orders, and agency orders related to COVID-19 to kind of check all of those boxes to make sure that we are in compliance. Now, another piece of Public Act 236 that's particularly important here is this piece related to, can you go back a little bit? This piece related to a requirement for persons to be in compliance with those pieces as long as they had not been denied effect at the time of the conduct or any risk that allegedly caused harm. So the big example here, right, is we now know, based on a Michigan Supreme Court decision back in the beginning of this month, that Governor Whitmer's executive powers ceased following April 30th under the Emergency Powers of the Governor Act. So any of the executive orders after that time became invalid. And so what this piece here is saying, right, they hadn't been denied legal effect at that time. And so following those in compliance gets you within what I'll call the protection of this law. And the next couple pieces that we're going to talk about seem a little kind of in the weeds, but there's a couple definitions here that are particularly important. But before we forward onto those, we'll just pause right here on another important piece folded into Public Act 236 that says any kind of isolated or de minimis deviation from strict compliance with those statutes, rules, regulations, or orders that are unrelated to a plaintiff's injuries does not deny a person the immunity provided in the section. So almost, right, kind of a recognition of saying, wow, the landscape here is huge, is not doing one thing going to take us out of the ambit of protection here, and not necessarily provided that deviation is kind of this isolated or de minimis type of deviation that is wholly unrelated to whatever injury a potential plaintiff is claiming here. So let's go ahead and jump to the next slide here, and we'll talk about a couple of definitions that I think are particularly important. So you remember in the beginning it said a person who acts in compliance with all of those rules is immune from liability for a COVID-19 claim. And so person is defined here really broadly. It's not just limited, right, to claims brought by employees, for example, and it's not just related to businesses, right? A person, just as you and I might think of it in normal casual conversation, can be an individual, right, partnership, corporation, association. You see all those indicated there. And of course, importantly, including but not limited to schools, colleges, or universities, institutions of higher education, nonprofit charitable organizations. And that's particularly important, right? When we think about the types of claims that persons could bring, we're not just talking about, hey, I'm an employee in the workplace and I don't think my employer is doing the right things. It's, hey, I'm a consumer and I go out to a restaurant or bar and maybe I don't think they're doing the right things, and I eventually end up with some kind of COVID-related injury that I could go back, right, potentially go back on that restaurant or bar and saying, hey, I think that you contributed to whatever injury I have here. And so this really broad definition of person is important. It covers all of those pieces. And importantly, in that second bullet point, of course, a person includes an employee, agent, or independent contractor acting on behalf of the person, regardless of whether the individual is paid or an unpaid volunteer, right? So it covers the employees of the restaurants, the employees of the grocery stores, that they cannot be right, personally liable under these protections for these types of claims as well. Let's go ahead and go to the next slide, please. Another really important definition related to this Public Act is kind of the definition here of a COVID-19 claim. Certainly, the landscape of those types of claims can be wide as well. And so this act particularly defines it as you see here on the screen. So a tort claim for damages, losses, indemnification, contribution, or other relief arising out of, based on, or in any way related to exposure or potential exposure. So kind of like the example I gave, if I'm a consumer at a restaurant and I think that, you know, whatever's happening in the bar or restaurant contributed to my exposure of COVID, or conduct intended to reduce transmission of COVID. So it forecloses the ability for an individual to bring those types of claims. So what a COVID-19 claim is not is an administrative proceeding or civil action brought by a state or local government or agency to enforce those statutes, regulations, and orders. So here, right, the PA 236, that is pretty broad type of liability protection. It isn't liability protection related to if you have, for example, my OSHA is an example, issuing you a general duty clause type of citation. It doesn't foreclose the ability for them to do that necessarily. So what are we talking about here? The other piece in this bill talks about what is also foreclosed is a tort claim made by or on behalf of someone else of an individual who's been exposed or any representative, right? So their spouse or family member for an injury, including mental and emotional injuries, death, so on and so forth. So you may remember at the beginning of the COVID-19 pandemic, for the types of organizations that were working, that never closed, right, during all of the various state shutdowns. And there were, customer, employee-related exposures, and family members of those individuals were bringing claims against the organizations based on their own potential exposure. So it folds those types of claims into the protection available here too. And so when we're talking about, tort claims, what are we talking about here? Claims for personal injury or wrongful death or even negligence, right? What this doesn't do is is remove any types of claims related to specifically workers' compensation. And so workers' compensation here in Michigan and in many states is the exclusive remedy available for employees who sustain personal injuries in the workplace. And so that mechanism does not go away because of this liability protection. Okay. The last piece, when we talk about conduct intended to reduce transmission of COVID, that definition is particularly important as well, because it talks about what types of conduct can that include. So that can include health screening, testing, contact tracing, or other actions intended to reduce transmission of COVID in the workplace or on the premises. So an example here, right, is we have Michigan Department of Health and Human Services order that requires masks in public places. And so now this liability protection, it forecloses the ability for a customer to bring a claim against a business, right, for taking that conduct intended to reduce transmission, right? So you're requiring me to wear a mask, and I might be interested in bringing a claim against you. That type of claim is folded into the protection of this bill as well. And so the last slide here related to PA 236 is related to, remember at the very beginning we talked about that isolated and de minimis deviations from strict adherence to those orders and statutes and rules doesn't take you out of the protection of the bill if those actions are unrelated to an individual's potential injury. But remember that just because you might do something that takes you out of strict compliance, right? So an example I might use is, for organizations that are operating, we're all required to have a preparedness plan and have it up on our website and easily accessible. So maybe you forgot to do that, right? You have it, but it's only at the home office, and you haven't shared the most updated one with your employees or something like that. It might not necessarily be isolated, right? Because that's kind of an ongoing thing that you've been out of compliance with. And it certainly feels like it's probably pretty far away from any type of claim one of your customers might bring that they've gotten COVID by visiting your workplace, because you haven't posted your preparedness plan. But for the sake of argument, let's just say it's taken out of the liability protection there. That doesn't mean that me as the customer bringing my claim doesn't still have to prove all of the elements of my type of claim here. So even if you can't claim the protection, an individual would still need to prove the requisite elements of a claim, like negligence, for example. So, right, those elements that the organization had a duty to protect me or a duty to follow certain orders. They breached that duty. They didn't do it. And I've sustained damages, but is their breach of their duty causing my damages? So the example that I gave related to the preparedness plan as an example, as an individual bringing a claim, I still need to prove that the organization's inability or failure to post that COVID preparedness plan is what actually caused my damages. So the important thing to remember there again, right, even if you kind of fall out of this isolated de minimis type of deviation piece, all is not lost. It just means that the individual, you've lost the first argument, right? They're not completely foreclosed from bringing a claim. They can bring a claim, but they still have to prove the elements of that claim. Okay. Now let's go ahead and move forward.
Sandy, let's pause there for a second because we have a question that I think we could answer before you move on. The question is, so if somebody tests positive for COVID and we are pretty sure they caught it from a coworker, would that be workers' comp? Can you talk just for a minute about the analysis that employer would want to do to determine whether or not it's workers' comp? And we don't have to go into detail, but I know there's a pretty detailed analysis that we would want to do before assuming that's a work-related injury that would fall under workers' comp.
Sure. Definitely. So I'll first start by saying it would depend on the type of injury, or the type of industry the individual is in. Michigan, the Workers' Compensation Administration, the agency that oversees that here in Michigan, they have an emergency rule that essentially is a presumption of being a compensable work-related injury for certain types of what I'll just broadly say kind of frontline type of individuals. Just kind of saying, yes, if any of these type of individuals contract COVID, we're going to go ahead and assume it's a workers' compensation compensable injury, and we're going to, follow the structure we have in place here in Michigan for that. Related to other industries, yes, and you may have heard Sarah and I talk about it a little bit more, it does hinge on this work-relatedness piece. Right. And so we think maybe we got it from a coworker because the coworker happens to have it, and maybe I was in the facility at the same time. But we want to dig a little bit deeper on that, and we want to learn a little bit more about. You're going to want to analyze the mitigation strategies that you've been taking in the workplace. Of course, you're going to want to do that close contact analysis. Was this person even a close contact of the person who has been exposed? What other things are going? What's the level of community spread? What is that individual's outside of work activities? And we're not going to dive into somebody's personal life too specifically here, but right? Do they have, children at home who are going to face-to-face school? Do they have a spouse at home who's working in, a healthcare type of industry? There's lots of different places. And so we certainly don't want to just presume that because we've got a coworker who's tested positive and now I've tested positive in the workplace that those things necessarily impact each other. I think where this gets a little bit gray is I know that the local health departments generally are presuming that two instances in this that can be kind of attributed to the same type of facility, as an example, kind of constitute an outbreak. And so we're seeing this a little bit in schools and what some of the guidance is related to when schools need to kind of close and everybody needs to quarantine. And that's, two cases. But that's not necessarily the same analysis, right? That's more from a public health, making sure that it doesn't continue to spread there and people stay put. And that's completely separate from the work-related analysis that we would do on the MIOSHA or workers' compensation side of the house. So that's just very, very broad, but generally that's how those two pieces go together.
Thanks, Sandy. And for those who are listening and are subscribers to the Resource Center, I know we've got some excellent materials on the Resource Center that take businesses through that workers' comp analysis and sort of walk them through it. And I know Sandy's taught a couple of webinars on that as well. So that would be a great resource too. Okay, moving on to Public Act 237. Tell us about that, Sandy.
Okay, thanks, Sarah. So that question was almost a perfect segue here as we start to talk about MIOSHA, right? So as we go into Public Act 237, you're going to think that maybe we're looking at a very similar to PA 236, all right? So it is very similar, in fact. So here, this is just making an amendment to the existing Michigan Occupational Safety and Health Act, and it adds this Section 85 that says an employer is not liable under this act, so that's the MIOSHA Act, for an employee's exposure to COVID if the employer was operating in compliance with federal, state, local statutes, rules, regulations, executive orders, agency rules related to COVID that had not been denied legal effect at the time of the exposure. So you'll see this is very similar to Public Act 236. And it, again, intended to clarify that an employer is not liable under the act for the employee's exposure, presuming that the employer is following all of those rules. So I think of the, Public Act 236 is almost kind of this external facing piece, right? That, hey, customers, these are the types of claims that can't come forward if we as a business are doing these types of things, or other claims even involving our employees. And Public Act 237 is a little bit more inward facing that, hey, employees, you bring a claim a personal injury claim or something like that against your employer related to COVID, but we're also not going to be in violation of any type of OSHA standard or rule if we do all of those pieces. And if we go to the next slide here, you'll see that this is very, very similar language to what we talked about in PA 236, right? An isolated de minimis deviation from strict compliance with those statutes, rules, regulations, executive orders that are unrelated to the employee's exposure to COVID does not deny an employer the immunity provided by that section. So very similar to what we talked about related to PA 236. And right, the example that I gave then still makes sense here. We forget to post our preparedness plan, and that might be a deviation from strict compliance here. But if that's totally unrelated to an exposure of COVID in the workplace, we're not necessarily falling out of the protection provided by this amendment. Next slide, please. But it's important to understand as well what PA 37 is not intended to do, what this amendment is not intended to do. So it's not intended, similar to what we talked about with 236, to create, recognize, or ratify any type of claim or cause of action, right? So we're not presuming that an employee could bring a private cause of action under OSHA, and this amendment isn't creating the ability to do that. It's not eliminating a required element of any other type of claim. Remember, we talked about that with 236, just because you might fall out of the protection because of a more than isolated de minimis type of deviation. Somebody bringing a claim still has to prove those causation elements. And so on the OSHA side, right, when we look at who's enforcing OSHA, that's the agency. And so for any type of standard or citation that they are issuing, there are necessary elements, right, to each of those types of citations. And so adding this amendment to OSHA doesn't eliminate the need for someone at OSHA to still do that before they issue a business citation, okay? And like we talked about similarly with PA 236, this amendment does not affect an individual's protection under the Workers' Disability Compensation Act. So what we just talked about, remember, the Workers' Disability Compensation Agency does have emergency rules related to COVID. It does have a presumption of a work-related compensable personal injury for some types of workers. But for others, we still have that work-related analysis that goes into that calculus. And here related to PA 237 and something I was remiss in mentioning related to PA 236, these bills are retroactive to March 1st. And so it's folding in all of our compliance with all of these rules and all of these executive orders all along. And so to the extent that you have a claim sitting out there from OSHA as an example, or right under 236, a private individual bringing a claim related to COVID-19 type of injuries, and you can show that you were in compliance with everything that was in effect at the time of the individual's claimed exposure, you can claim the protection of this act. As we specifically look at OSHA, not going to make any citations go away necessarily, right? Unless, right, you can show that the citations were not based on violations to begin with, right? So if you got a citation, as an example, the general duty clause because you weren't doing daily health screenings, this is just an example, but you can show that you were doing daily health screenings consistent with what the executive orders required of you at that time. That's a defense to you now and was a defense to you, quite frankly, before the amendment to this act. Okay.
Thanks, Sandy. That's excellent. And I think re-emphasizes and maybe helps re-energize us to make sure we are keeping track of, staying on top of what the requirements are. I know it's getting tedious. I know a lot keeps changing and continues to change. But the idea that we can enjoy this liability from private causes of action and from OSHA claims by substantial compliance with the state and federal laws, the executive orders, et cetera, I think is really important. And again, for those who subscribe to the Resource Center, I do want you to know that we have completely updated all of the materials on the Resource Center to reflect the DHHS order, the OSHA order, evolving CDC guidance, et cetera. So if you haven't gone on there yet and gotten the new and revised preparedness plan, the revised daily health screening forms, et cetera, please do that to make sure you stay in compliance, okay? All right, let's move on to what we're calling Public Act 238. Unfortunately, they didn't give this law a name, so we might be stuck with just calling it Public Act 238, which is really kind of a bummer in my view, but that's okay. This is the law that puts into legislation what we previously knew as originally Executive Order 36, then it turned into 66, and it turned into 172. And those were the executive orders that required employees to stay home if they had been exposed to COVID or if they had tested positive or had symptoms of COVID. And it also said that employers couldn't take any employment action against them for doing that. So it's very similar to those executive orders, but as you'll see when I explain it, it does have a few exceptions, okay? So first, just very, very high level, Public Act 238 does mandate, it's an individual mandate for your employees. It tells them they shall not come to work under certain circumstances. Now, interestingly, it says they shall not work. It does not isolate or quarantine them from doing other things than work. The local health department likely would do that because all of the reasons for which they're not supposed to work under Public Act 238 are also reasons that a local health department would probably tell them to quarantine or isolate. But the words in this particular statute just apply to work. It creates a civil cause of action. That's something that the executive orders did not previously do. What that means now is this is a law, this is a statute under which your employees can sue you. So for example, if you count absences that were caused by a reason that fell under the act, let's say an employee called in and says, I'm not coming in today because I have a fever. Okay, that's one of the primary symptoms of COVID. Now, if we count that under our attendance policy in violation of Public Act 238, and that leads to an employee receiving discipline or getting fired, they have a claim, a legal claim against you. Okay, think of it sort of like FMLA gone crazy, right? So we have protection, job protection here for time away from work that is for reasons that are a much lower standard than the FMLA applies, and with no cap. So there's no, it doesn't say it's only 12 weeks per year. And that civil action can result in damages and injunctive relief. The minimum amount of damages available is $5,000. So let's say an employee gets an attendance point, right? They didn't actually suffer economic damages because they didn't lose their job over that. Well, they can at least file a lawsuit and get $5,000 out of it. It's retroactive to March 1st, which is very, very strange. And we're still sorting out, quite frankly, what that could possibly mean. March 1st is before even Executive 36 was in effect. It's almost a month before, or I think over a month. I think it was around April 1st or 2nd that Executive Order 36 entered our lives. And so according to this law, employers can be held accountable for requirements that were not in place at the time that they acted. And so that likely would not be enforceable in a court. I think the legislature put it in there because it put it in there for Public Acts 236 and 237, and it was part of a package deal. But as it plays out, doesn't make a whole lot of sense. This is the part that is frightening to me, I'll be quite honest. There is no automatic sunset provision under Public Act 238, okay? So you guys are probably assuming that when I talk about attendance protection for employees missing work for symptoms of COVID, that will go away when COVID primarily leaves our lives. That is not the case. This law will continue as it's written right now. It will not sunset out at any particular time. It could get rescinded sometime in the future, but that will not be automatic, okay? So that means in 2021, employees, even if everyone's been vaccinated for COVID-19, COVID-19 probably will be present in some capacity in our communities, and employees can continue to call in for fevers or for uncontrolled coughs, et cetera, and enjoy that attendance protection for them. Okay, and I'll just say too that sunset provision is an interesting result of the odd way that these COVID requirements are now being imposed through legislation rather than through agency or executive orders. One downside of that is legislation is very unwieldy. You can't as easily amend it or rescind it as you can with agency and executive orders. So it is a law that is now in place and will not change until we have a legislature that will vote to change it, okay? All right, so let's talk about what it requires, what it does. The first piece of it relates to isolation. So the term isolation applies when we have somebody who has tested positive for COVID-19 or has one of the primary symptoms of COVID-19. They are required to isolate, okay? So if somebody tests positive for COVID-19 but has no symptoms, they can't work until 10 days after the date of the test that yielded the positive result. So it's the date of the test, it's not when they got the result, which could be, as we know, a day or a few days later, okay? If we have an employee who displays any of the primary symptoms of COVID-19, and I'm going to tell you what those are in just a second, okay? And this is whether or not they have a positive test. They don't have to have gotten tested necessarily. If they even have the symptoms, they shall not report to work until, and these will sound familiar to many of you, 10 days have passed since symptoms first began, and they have to be 24 hours fever-free without that medication, no Advil, no Tylenol, et cetera, and their principal symptoms have improved, okay? Then if we have an employee who tests positive and has symptoms, they can't report to work until the later of the date of the test or the date symptoms began, okay? And it's the later of those. And then also 24 hours fever-free without medication and symptoms have improved. So I tried to break that down into three different categories because the way it's written in the law is very confusing, and we're getting a lot of questions along these lines. What if somebody has symptoms but didn't get tested? What if somebody has symptoms and got tested? Or what if somebody got tested but doesn't have symptoms at all? Okay, so I broke that down in that way. I do see a quick question, can employees still work remote? Absolutely. It says they cannot report to work. I interpret that to mean report to the workplace. If they are isolating at home, then I don't see any problem with that. Okay. So let's talk about the principal symptoms of COVID. Okay. The law, the legislation, first defers to the definition provided by the director of the Michigan Department of Health. Okay. So as that director might revise, it's a he, his orders, right? As Robert might revise his orders to change the definition of principal symptoms of COVID, then that gets folded into how this law defines those symptoms. Okay, so we already have one emergency order from the Michigan Department of Health that was October 9th, and that defined principal symptoms as follows. There's two categories. You can have one of a fever, uncontrolled cough, or new onset of shortness of breath. If an employee has any of those, then they have one of the primary symptoms of COVID. Or the second category is an employee could have two of the following that are not explained by a known physical or medical condition. And those are loss of taste or smell, muscle ache, sore throat, severe headache, diarrhea, vomiting, or abdominal pain. Okay. Be careful, and I know this is getting into a bit of detail here, but the way the Michigan Department of Health defines primary symptoms, that first category, the fever, uncontrolled cough, or new onset of shortness of breath, is a primary symptom of COVID. And it doesn't have that qualifying language that the second category does that talks about whether it's explained by a known physical or medical condition. In other words, it doesn't dig into whether a fever might be explained by something else, whether an uncontrolled cough might be explained by something else, or whether a new onset of shortness of breath might be explained by something else. Instead, they just automatically would be a primary symptom of COVID. I have no idea if the director did that intentionally. That is not how OSHA defined it, but that is how the words read in the Michigan Department of Health emergency order. Okay. Okay, I have one question here. If somebody in the workplace tests positive, any notice to employees about potential exposure should not identify the employee who received the test. So that's a question related to a positive test protocol. And yes, we should not explicitly call out the name of the employee who tested positive because of ADA confidentiality concerns. Of course, as we do our contact tracing, quite frankly, in most cases, individuals figure out who that is, but we don't call them out by name in any communication to employees about somebody who tested positive. Okay, so those are the isolation requirements in Public Act 238. Let's talk about the quarantine requirements. And quarantine refers to what employees have to do if they've had close contact with a person who either has tested positive or has displayed the primary symptoms of COVID, like we just, and those are the symptoms that we went through. And again, I am going to talk a minute about what close contact means, okay? So the quarantine requirements under this law are 14 days since last close contact with that individual, or the individual with whom the employee had close contact tests negative. In other words, there is confirmation that that individual didn't have COVID, okay? And so let's say I go running with my friend in the morning, and she calls me the next day and says, "Hey, Sarah, I just woke up with an uncontrolled cough. I thought you might want to know." Okay. I initially am under the requirements of this law to now quarantine for 14 days because I had close contact with her. We ran for more than 15 minutes and we were within 6 feet of each other. If she called me 2 days later and said, "Hey, Sarah, good news. It turns out my uncontrolled cough was not COVID because I've just tested negative," under this law, now I am no longer required to quarantine. Okay. Note, okay, the CDC in their recommendations have specific exceptions to this quarantine requirement for healthcare workers and for critical infrastructure employees. This law does not include all of those exactly as the CDC has laid them out, okay? But it does have an exception to only the quarantine requirement. So that's the close contact quarantine requirement for healthcare workers and others, okay? So those quarantine requirements, and again, that's only the piece that applies to close contact, and the law says that does not apply to healthcare professionals, workers at healthcare facilities. I've laid out who those are: first responders, child protective service employees, workers at child caring institutions, workers at adult foster care facilities, and workers at correctional facilities, okay? So it is not as broad as the CDC guidance had allowed for critical infrastructure, okay? And what that means is we do have to comply with this Michigan law, okay? So the statute itself defines close contact as being within 6 feet of an individual for 15 minutes or longer, okay? I do note that late last week, the CDC changed its definition of close contact to say that 15 minutes can be not sequential, right? It can be for shorter periods of time than 15 minutes if within a 24-hour period, the time that I spend with somebody and within 6 feet of a person adds up to 15 minutes. That makes a big difference to many employers who have employees maybe working on production lines or in the retail setting, et cetera, okay? So the CDC definition of close contact now is different than what this law says, okay? This law says 15 minutes or longer, and I think you can read it to say that has to be in a row. From a practical standpoint, what that's going to mean is likely when our local health departments do their contact tracing and they make their recommendations to individuals as to who needs to quarantine, they are going to follow the CDC standard. Okay, so they may be telling your employees that they have to not work for 14 days under the CDC's broader standard, but those employees may not fall into Public Act 238. You still should, of course, not discipline them or take action against them for following what the local health department is telling them to do. And in fact, that would violate the current DHHS emergency order to do that anyway, okay? All right, under Public Act 238, as I mentioned, there is a civil right of action. When employees are missing work for the reasons under this law, we can't discharge them, discipline them, or retaliate against them, okay? There's an anti-retaliation provision saying we can't retaliate against employees who oppose a violation of the law. In other words, if we require somebody to come to work even though they've had close contact with an individual with primary symptoms of COVID, and one of our employees says, hey, you're not supposed to do that, we can't retaliate against them. And interestingly, they threw in sort of a OSHA retaliation claim under this law too. So anybody who reports any health violation related to COVID-19 can file a lawsuit under this statute too. So it's another cause of action for employees who do that. So you should be aware of that. Importantly, employees don't enjoy that civil right of action if they have primary symptoms of COVID. We ask them to take a test to see if they have COVID or not, and they fail to make reasonable efforts to do that within 3 days. Okay, so remember at the beginning how I sort of scared you all by saying this law is going to be around and provide attendance protection even after COVID has the impact that it's having today in our lives. That is likely going to be one of our primary ways of addressing potential abuse, right? If we have employees who are calling in saying, I can't come to work today, I have a fever, I have a cough, etc., we can say to them, all right, you've got to go get tested for COVID then if you want to enjoy the protection of this Michigan statute. This next slide, I got a little ahead of myself, but here's the definition of close contact under the law. And I mentioned here that the CDC guidance had changed late last week. So all of that information is in this slide too. All right, let me see what questions are floating around out there and see if I can answer those quickly before we head into our Mondays. What is considered a medical determination? Well, that is not a defined term. Is it simply a negative test? Certainly, it could be a negative test. I think the way it's written raises the argument that it could also be something from a medical provider concluding that this person does not have COVID as well. Those are the types of situations, though, that you're going to want to take on a case-by-case basis and probably be working with your legal counsel to make decisions about whether you're going to discipline somebody for failing to come to work under those circumstances. What if the individual, next question is, what if the individual with whom there's close contact never seeks COVID testing? Well, then that means your employee is going to be required to quarantine for 14 days after last contact with that individual. Next question, is worker the same as employee? We work in hospitals but are not directly employed by them, et cetera. The law, again, does not define worker, so I would say yes. And in fact, I'm looking at the law now, and it uses the term employee specifically, and it means an individual employed by the employer and whose primary workplace is not the individual's residence. So these are not only employees, but people that are required to perform in-person work in a workplace. So if you work in a place but you're not employed by them, you're not, those individuals, whoever they are, contractors, et cetera, likely do not fall under this law, et cetera. Okay, last question. Can employees be disciplined up to termination for not communicating that they had close contact? Hold on. I got to scroll back up. with somebody who's positive are positive or attempting to hide symptoms that should keep them home. In other words, what if we have the opposite? What if we have employees coming to work after knowingly been exposed to COVID and potentially endangering others in the workplace? So if you're doing what you're supposed to be doing under the DHHS order and the MIOSHA order, these individuals should be completing their daily health screening protocol in which they're specifically asked these questions, which would mean they probably lied on that before they came to work. If that is the case, then absolutely you can discipline them for dishonesty in the same way that you would discipline other employees for dishonesty, okay? All right, I see a few other questions, but I think those are questions we can answer online, and so we will take care of those. Thank you all very, very much for attending the webinar this morning. We have several more this week. The regulatory landscape is changing again, so we will keep you all informed and up to date. Have a great day.
Thanks, everybody.